seat and make yourself comfortable. Thank you. Good morning, ladies and gentlemen, to the Honorable Dr. Trilaksmi Indraswari, SIM, Vice Dean for Academic and Student Affairs, Faculty of Law, Universitas Diponegoro, to the Honorable the Guest Lecturer, Associate Professor Tania Lehman, LLB, GDLP, DCE Professional Certificate, Dean of Law, College of Business, Government and Law, Flinders University. A very warm welcome we bid to all of the participants, Faculty of Law students, Universitas Diponegoro. I would like to express our heartfelt gratitude for your presence at this memorable occasion. It is indeed a pleasure to have you all here today. And thank God for his blessings so that this morning we could gather here virtually in this general lecture regarding law in a digital age. Before we begin the agenda, please allow me to read the rundown of the session this morning. First, there'll be a welcoming speech from Dr. Trilaksmi Indraswari, SIM, Dean of Faculty of Law, Universitas Diponegoro. Second, the lecture will be opened by the moderator, Mrs. Anggita Doramia Lumban Raja, SIM. And third, the presentation will be delivered by the guest lecturer, Associate Professor Tania Lehman. And at the end of the session, there will be a short question and answer session. Ladies and gentlemen, without further ado, we are now going to listen to the speech delivered by the Vice Dean of Academic and Student Affairs, Faculty of Law, Universitas Diponegoro, Dr. Trilaksmi Indraswari, SIM. The time is yours.
Assalamualaikum warahmatullahi wabarakatuh. The Honorable Associate Professor Tania Lehman, LLB, GDLP, GCE Professional Certificate, Dean of Law, College Business Development and Law, Flinders University, Anggita Doramia Lumban Raja, SHMH, as a moderator. Good morning, all the participants. Alhamdulillah. Let's ask thanks to Allah Subhanahu wa Ta'ala, who has been give us bless and prosperity, so we can join the visiting lecture today. On behalf of Faculty of Law, Universitas Diponegoro, I deeply honored to welcome Dr. Tania Lehman from Flinders University as the visiting lecturer in virtually. I would like to express our heartfelt gratitude for Dr. Tania for accepting our invitation to join the visiting lecture today. The theme of visiting lecture today is Law in a Digital Age. That's an interesting theme because we already know that the phenomenon of digital society becomes the object of many scientific disciplines. It's applied in many branches, scientific, of the humanities, technology, building bridge between the discipline, and law stands among them. We hope that the fitting lecture today intends to develop our students' knowledge about the latest issue, especially in digital age. We do hope the collaboration between Flinders University and Faculty of Law University Diponegoro can be implemented continuously in the future. For all the participants, Thank you for joining the visiting lecture today. Enjoy the visiting lecture. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you very much, Dr. Trilaksmi Indreswari, for the speech. Ladies and gentlemen, the moderator that will guide and conduct this discussion is Mrs. Anggita. Therefore, beforehand, I would like to introduce our moderator based on her CV. Please allow me to introduce the moderator. Her name is Anggita Doramia Lumbanraja, SHMH. She was born in Lampung, August 18, 1991. Her educational qualifications are as follows. She attained her bachelor degree in Faculty of Law, Universitas Diponegoro, and also her master's degree in Faculty of Law, Universitas Diponegoro. She is now a lecturer in law in Faculty of Law, Universitas Diponegoro. Mrs. Anggita, the floor is yours.
Thank you very much, Daniel, as our host for today. Good morning, ladies and gentlemen, the honorable, distinguished guest lecturer, fellow students, and all of the participants. First of all, I would like to welcome all of you to this prestigious general lecture about law in digital age. My name is Anggita Doramia Lumanraja. I'm lecturer in law, Faculty of Law, Universitas Diponegoro. It is my pleasure to be a moderator for this general lecture on law in digital age. Ladies and gentlemen, before we start this general lecture and in order to avoid any disturbances during the presentation later, I would like to ask you to mute your microphone, and so please notice your microphone button on the mute mode. And there are several pieces of information that I would like to give to you before we start this lecture. First, the general lecture will take a time from 10:30 until 11:30 in Semarang time or 2 until 3 p.m. in Adelaide time. So our lecturer will deliver her lecture maximum in 45 minutes. Second, the participants are allowed to write down their questions, of course in English, in chat column of this virtual meeting room. Please ask your questions briefly and clearly, the appropriate words. And don't forget, please make sure your questions are relevant with the topic of this general lecture. Third, the question and answer session will be opened by moderator right after our guest lecturer finishes her presentations. In this questions and answer session, moderator will choose 6 until 9 questions from the chat column and will read them for the lecturer. Ladies and gentlemen, before this presentation begins, may I briefly introduce to you our guest lecturer for today. Her name is Associate Professor Tanya Lehman, LLB, GDLP, GCE Professional Certificate. She is a Dean of Law in College of Business, Government and Law, Flinders University, Adelaide, Australia, from August 2017 until now. Her educational and qualifications are as follows. In 1986, she graduated her bachelor degree from Adelaide Law School. In the same year, she admitted as a barrister and solicitor of the Supreme Court of South Australia and High Court of Australia. In 1987, she got her graduate diploma in legal practice or GDLP from South Australian Institute of Technology. Now it's known as University of South Australia. In 2010, she got her graduate certificate of education in higher education or GCE from Flinders University. Dr. Tenelman also has many work experiences as a legal professional. She started her professional career in 1987, working as a barrister or solicitor for Raleigh, Bayshire Downs, Humphreys, or Raleigh, Ahern and Karen until 1992. And in 2010, she became a senior solicitor in Dorsey Bath and Associates until 2011. She started her academic career in Flinders Law School from 1994 as a tutor. Besides that, she also gave her contribution to her alma mater. In 2009, she became a tutor in Adelaide Law School. She also participated as a lecturer, internal tutor, external tutor, online course coordinator in School of Psychology, Social Work and Social Policy University of South Australia in 2005 until 2010. Some of her significant publications include: first, integrating human service law and practices. She published it in 2016 with Archie Kennedy and G. Richards. This publication has been cited 3 times based on Good Scholar indexation. Second, where are the graphics? Communicating legal ideas effectively using images and symbols. She published it in 2017. This is a publications in Legal Education Review Journal, volume 26, number 2. It has been cited 3 times. And third, Law and Tech Collide, Foreseeability, Reasonableness, and Advanced Driver Assistance Systems. This is as her publications this year in Policy and Society journals. And there's a lot of more of her publications. Ladies and gentlemen, without further ado, I would like to welcome our guest lecturer to begin the presentation. Dr. Tanya Lehman, the floor is yours.
Thank you very much, Angita. I'm going to share my screen. I hope my screen is sharing and that you can see that, everybody there. I would like to thank you for your very warm welcome, and it is my honour and privilege to join with you via Zoom this afternoon, my time, this morning, your time, for this lecture. I'm delighted to speak to you from South Australia and Flinders University, and these are some of the photographs of my campus. If you're wondering where I'm speaking to you from, I'm speaking to you from Adelaide in South Australia, which is at the bottom in the centre where the red dot is on the map. And this is another image from our campus. My theme today is law in a digital age, and I want to speak to you in 3 parts. First of all, to discuss future mobility and whether that may be an analogue for us to consider legal change. I want to move on to think about law, data, and the platform economy. And my third and final section will just introduce you to coding and apps and some of the work that we're doing at Flinders University. So let me start with future mobility, an analogue of legal change. I'm going to be making 3 short points under this section. Firstly, that traditional taxonomies or ways that we characterise things no longer fit, that existing frameworks no longer fit, and that data in the context of mobility is as important as movement. When we think about vehicles and search for icons on the software that we use, these are the icons that come up and we recognise them. But those icons don't cover the field. There are a number of things that are missing. And here's a list of some of the things that might also be included there. The Segway has just recently been discontinued. The acronym AV there means automated vehicle. Pneumatic is an underground system of moving money and documents around in Paris that's existed for over 150 years. MAAS means mobility as a service. RAAS means ride sharing as a service. And even that list doesn't cover the field. When we think about the future of mobility, we can also think about usage-based insurance, smart infrastructure, smart cities, the Internet of Things, and devices that can communicate between vehicles to everything else, between pedestrians to everything else, and everything to everything else. So I'm talking here about a context of mobility that moves far beyond just a car or a motorbike or a bicycle or a boat or a train to all sorts of devices and tools that are connected to the internet, that generate data, that collect data, that can be added to humans to enable them to move around more safely, more quickly, and more effectively. And in that whole environment, we need to think about how we manage people moving around in cities, how we manage to insure them. That's already what the framework for future mobility looks like. And we haven't yet got to a situation where we have fully automated vehicles that are transporting us around. That day may come, but it's still a way off. But even now, our existing legal frameworks no longer fit. In Australia, and it may well be that in Indonesia as well, our road traffic laws include words like this: reasonable, care, take a proper look out, be in control. And when we're thinking about whether someone is liable or not for the harm that they might cause if they're driving a vehicle that collides with something, we might use words like intention or negligent, reasonable, competent. All of those words are words that we would apply to human beings. They're not words that we might apply to machines. When humans started moving around this planet, they did so on their own two legs. And then, of course, we started riding animals. But the fastest we could go was reliant on our own speed or the animal's speed. But now, as we use cars and bicycles and motorbikes, we now use mechanised speed or force. And increasingly, we are moving to a world where we'll use digital speed and force. And so what that means is we've moved from a situation where we've got humans making decisions to humans making decisions and working with machines, and then increasingly where we have machine intelligence that uses data to drive decision-making and to drive mechanical or digital action. And in the context of motor vehicles, what that means is that when we started walking or riding a horse or some other animal around, if we had an accident, the injury was likely caused by either the animal, you, or somebody else that you know or who has responsibility to care for you. As we move into the mechanised age, the chances are that those injuries or harm might be caused from people more distant from you, people that you can identify and hopefully have some form of insurance to pay for your loss. But when we move into the digital space, then injuries might be caused by someone or something that we can't identify, who may be in another country and who may have no insurance within which to pay for your loss. We're moving from a world where human or animal speed or force is regulated by the law. And humans have a choice to either recklessly or negligently breach the rules. When we have mechanised speed and force, we move to a world where the law regulates technology. And here in Australia, we have a situation where we have laws that cover the whole range of a vehicle's life cycle. From the time a car is imported into our country, it's assessed as roadworthy, it has to be insured and licensed, drivers have to be licensed, all regulated by the law. They have to pay for those licence fees and insurance. There are road rules. And if you breach the road rules, you might well be subject to the police bringing charges against you. As we move into a world where increasingly we have mechanised speed and force, we can see that, digital speed and force, we can see that now artificial intelligence, algorithms, machine learning start to assume the role of the regulator. And what happens is that machine learning systems using automated decision-making or data-driven inferencing can identify risks that could not be identified by humans and potentially shut everything down before the rules can be broken. Here in Australia, we have at least three remote mine sites, large mines, where all of the trucks on those mine sites are autonomous vehicles. There are no drivers. The vehicles are completely autonomous. And those mine sites, established by a particular company, operate on the basis that those trucks can sense everything in their surrounding, and if there is any chance that those trucks might collide with something in their pathway, the whole system shuts down. And that's what I mean about AI shutting everything down before the rules can be broken or before harm can be caused. And so when we think about that in a legal context, we start from a position where humans know or ought to know about risks or rules, to a situation where machines can be programmed to obey those rules or avoid risks. And in some cases, it might be that cars have speed limiters applied to them, or trucks can only go up to a certain speed. Increasingly moving then to a time where the real-time big data that's being gathered and the opportunity to mine that data to look for patterns and correlations can identify previously unknowable potential risks. So as human beings, we balance risk and reward all the time. If I take this action, what's the risk that I might cause harm to somebody else? What's the risk that I might break the rules and suffer some sort of penalty? And that assessment of risk and reward changes the way we decide to act. Machines, of course, operate only either as expected and programmed, or they malfunction. Machine intelligence uses data to identify the optimal action to achieve a particular desired outcome. And so while we as humans have to make decisions about whether we're going to drive too fast or go through a red light or a stop sign or not wear a seatbelt when we're required to, instead, when we're thinking about machines, they can't make those decisions. They will operate as programmed, or someone has hacked the machine to make it malfunction. In the context of AI connectivity, where we have multiple moving devices connected together through the internet, it's possible, of course, to shut things down in the mining example that I've just given you before rules can be broken. What we can see from all of this, though, in the context of future mobility, is that data is as important as movement. This is a picture of Henry Ford's first conveyor belt construction of Model T Fords. He wasn't the first person to build a car or to create it or to manufacture them in this sort of way. But what he did do was make vehicles affordable for a wide range of people. According to Wikipedia, a really interesting source, because we have multiple people collaborating on that in real time internationally, Ford converted the automobile from an expensive curiosity into a practical conveyance that would profoundly impact the landscape of the 20th century. I've recently read this book by Shoshana Zuboff, an emeritus professor from the US. I commend it to you. She makes some very, very interesting points about the role of data mining, data processing in our world. And following my reading of that book, I've revised the Wikipedia comment about Henry Ford and vehicles. And I instead want to suggest that data converts mobility, or the way we get around, from an interesting way to get around into behavioural surplus products, all of that data about us, that can then be fabricated into predictions about where we might go, what we might do, profoundly shaping how we live and act in the 21st century. I've got some other quotes here, but because of time, I'll just move through them quickly. What Zuboff says, though, is that once we thought of vehicles as being there to move us around, and that the auto companies wanted data, now we can flip the way we think that. And instead, it's the data generated by the movement that is the important thing and the valuable thing. That's the end of part one. Now I'd like to move, thinking about the picture that I've just painted, to looking at law, data, and the platform economy. What can we learn from our discussion in part one about future mobility as an analogy that we can bring to the legal profession? I've reframed Zuboff's quote again and said and proposed to you that data profoundly impacts the legal rules and tests that rely on human decision-making and will shape how we live and act in the 21st century. We live in a world that has moved from scarcity of information to available information, and now I would suggest to you overload of information. We have enormous amounts of information that we can access at the click of a finger via our smartphones. And when we're thinking about big data or the amount of information and data that we have available to us, this is a useful way of thinking about it. We have data that's coming at us at speed, that's of high value, and lots of it, and lots of variety. I also want to commend to you the work of Julie Cohen from Georgetown University Law. She's written an excellent article called Law for the Platform Economy, and also her more recent book, Between Truth and Power. And she described how we are moving increasingly to an economy that works on platforms like Facebook, like Amazon, like Instagram. This is a really accessible, quite short book written by a UK academic. Julie Cohen argues that these new forms of connectivity, the way that we spend so much of our life now online, connecting with each other, shopping, engaging with the government, doing all sorts of things, are reshaping every area of human activity. And the goal of those platforms is to be an indispensable point of mediation. If we need something, we'll go to Amazon. If our first port of call in terms of thinking where we might need to go, Google Maps. And so what she argues is that these platforms now are reshaping the narratives for us about reality, value, and reputation. So I want to now reframe the phrase again once more and propose to you that data and platforms impact what we see, hear, think, and feel, and are already profoundly shaping who we are and how we interact with our world and with each other in the 21st century. So thinking back to part one and my proposal around the movement that we've seen in future mobility, how might we apply that to the legal profession? Well, we start with a situation where human judgment, the human lawyer's judgment, was based on our own knowledge, our experience, and the perception we have through our senses. And the outcomes of our decisions were based on objective and subjective assessment of what we would call the real world. And our personal, moral, ethical, and personal, moral, and ethical frameworks were internal imperatives acting on us as we acted within external regulatory frameworks. But increasingly, as lawyers use data and operate on the platform economy that I've just talked to you about, our human judgment is augmented by not only our knowledge, but data, which allows us to access the knowledge, experience, and perceptions of others, not just ourselves. It helps us undertake a critical analysis of the additional available data to generate previously unknown options, because now we can see much more of what the broader landscape looks like. And so in this context, we also have to acknowledge that we operate in these external regulatory, economic, and external imperatives that drive and constrain decisions. And some of those are things like search engine optimization. How is it that the first result on your search results has made it to the top. There's a whole framework behind all of that. So humans, moving to humans augmented by data, moving to data mining itself, taking the humans out and allowing algorithms to mine very large data sets to identify patterns not otherwise observable by humans. And in this context, we have machines that use data to identify optimal actions to achieve the desired outcomes, even though humans could not or would not have thought of that. And what Cohen and Zuboff and a number of others argue is that the platforms are using that data to nudge us in particular directions, to modify our actions, to control what we see, hear, and are exposed to, and increasingly to automate action. So we're moving from a space that was just human lawyers or an advocate to being someone where our advice is mediated. We'd mediate data-driven advice, and then potentially situations where we aren't involved in the loop at all, and the data drives unmediated decision-making or action. And I'd suggest to you that means that those who are looking at entering the legal profession need a whole new lot of skills as well, not only just legal knowledge, professional competencies and soft skills, but also competency around the technology and an understanding of how software development and data analysis works so that we can use it for our own purposes and understand the risks and the benefits. Some recent discussions on this that you can access have been really useful in informing my understanding of this. So Lord Philip Sales, Justice of the UK Supreme Court, gave a lecture at the end of last year, almost exactly this time last year, where he talks about the progress from human decision maker to human guiding algorithmic decision to an AI decision maker. Julia Poor, a professor of American history at Harvard, talks about the same progression, this progression from fact being the important thing to number and statistics being the important thing to data, with, as she suggests, a movement from a focus on truth to a focus on control and power to a focus on prediction. I'm just going to skip over the next couple of slides because of time. I recently became aware of this article by Professor William D. Henderson from the US, Indiana University, a really useful one about innovation diffusion in the legal profession and the legal industry. So I've just talked about this progression from human lawyer to human lawyer augmented with data to data-driven legal outcomes, mirroring what's been happening in the context of mobility. Human or animal, human using a machine, fully automated machine. But is the legal profession ready for this innovation? This is it's quite a long article. It's available it's not behind a paywall, so I encourage you to read it. I think it's about 83 pages, but it is worth a read because he maps out the process, of adoption of innovation. One of the really interesting examples that he gives is the comparison between anaesthetic, the adoption of anaesthetic in the medical context, and antiseptic. So before anaesthetic, people who underwent surgery were in extreme agony. They screamed. It was awful for surgeons trying to conduct surgery while a patient was conscious. But once ether was discovered as an anaesthetic, that completely transformed the job that surgeons had to do and the experience for patients. And in about the early 1800s, that innovation spread around the world within about 6 months. And within about 6 months, everyone that was doing surgery was using anaesthetic. A little bit later in the 1800s, John Lister in the UK discovered the importance of keeping things sterile, and in particular antiseptic. But it took much, much longer for antiseptic and the process of sterilisation to become important in the medical context. What was the difference between them? For anaesthetic, it was only the surgeons that had to make the change, and they could do it very easily. To introduce sterilisation and using antiseptic, we needed every single person involved in the chain to make a change, not just the surgeons, but the nursing staff, the orderlies, all the way down to the janitors, the cleaners, the patients themselves, the people who manage the sewers, the people who clean the streets, etc. And those broad changes took much, much longer to come into place. But now, of course, we would expect that if we went to have surgery, there would be sterilisation. Henderson contrasts the slow but valuable innovation that antiseptic was. And so I think it's important for us to think what that might mean in a legal context. What's the legal anaesthetic equivalent and what's the legal antiseptic equivalent? Professor Henderson goes on to say that the relative advantage of slow innovations is steadily increasing over time because more and more people cannot afford legal services that rely upon artisan methods of production. An anaesthetic is a costly thing. Keeping your house clean, your operating theatre clean, they are expensive in the longer term, but the skill level is not required, is not the same. So that brings me to my final part of my lecture today. What can we think about as we think about slow but valuable innovations? Innovations that might be accessible, affordable, and that might bring big changes, not just to individuals, but as in the case of sterilisation and antiseptic, to broad public health impacts. What might be the legal analogies there? So I come to my third section today, which focuses on coding and apps. And I particularly want to think about this context that we've all lived through this year of COVID, challenges around access to justice, and how lawyers might think about learning to write apps. And I want to acknowledge here my colleague and collaborator, Mr. Mark Ferraretto, who's a lecturer in law with us at Flinders and who has been instrumental in setting up many of the programs that I'm going to talk to you about. Excuse me for 1 minute. So before COVID, and I'll speak now just about the Australian situation, although you may have parallels in Indonesia, it was difficult for many Australians to access affordable legal information and advice. And what we found was that whilst there was some government funding available, the eligibility criteria made that almost inaccessible. We have a number of benefits that people can access in this country that are provided by our government. They're usually set out in pieces of legislation, but the eligibility criteria for things like an unemployment benefit or a disability benefit or an age pension are often very complex. And so people need legal advice about that. Many Australians need assistance to prove that they're eligible. And if they can't do that or can't access that eligibility, it may mean that they have to go without benefits. They can get some assistance from not-for-profit agencies, but those agencies increasingly have limited resources, lack of trained staff. And so the situation before COVID was that not everyone in Australia can get the legal assistance that they need. The access to justice literature calls that the missing middle. Unless you are the very poorest or people who are very well off, accessing a lawyer can be out of reach. Now, of course, we've just lived through COVID. And so what happened in our country was that as of March, many government and not-for-profit agencies closed their offices or went to remote working. And that made it even harder for Australians to access information and advice. And yet people still needed information about their legal rights, and they needed it in ways that were accessible to them. They needed perhaps even more than they had before. It had to be accessible and available. And what's also happened as a result of COVID, and we're experiencing it now, is that many of us are so much more familiar than we ever were with online services. 12 months ago, I don't think I would have been giving a Zoom lecture like I'm doing today. And I wouldn't have had the 189 participants who are joining us today from all over the place. I recently participated in 215 participants now. I recently participated in the Global Innovation Summit in Pakistan with people all across Asia. There is no way I would have been doing that prior to COVID and the experience that we've all now had of living our lives online. So there's been some benefits. But what we also know is that as our country, your country, and hopefully other countries slowly come out of COVID and this pandemic, it's likely that the funding is going to continue to be very limited for not-for-profits or government agencies, and in fact, the funding might become less. And yet at the same time, we have more people that need legal information and advice because many have lost jobs or are facing financial challenges. And what the access to justice literature shows us very clearly is that if people can access early information about the law and their rights, then that can prevent quite serious legal problems later. And so what people need is tailored, affordable, scalable solutions to provide that personalised information. And so we're just starting to see now in so many places and different contexts that apps on your mobile device can really increase access to justice. They can be direct to customers, or they can help government or other agency staff provide accurate information to more people more efficiently, even without formal legal training. And the use of algorithms and machine learning can enable people to be given personalised information without the need to travel. Whatever we can do to streamline complex legal rules so that more people can understand them, the better. And as I've already said, early information can prevent later problems, and ideally we want to make the opportunity for people to access this outside of a proprietary paywall. Open access, affordable, transferable, free. So I want to tell you, just as I conclude, about some of the work that we are doing at Flinders. For the last 2 years, last year and this year, we've been teaching a topic which became compulsory for all of our students this year, called Law in a Digital Age. Our students come in as law students. They're not there to study computer science. And they come in with almost zero knowledge. And yet in the space of 12 weeks, the resources that we've put together using the platform DocAssemble, an open source platform, allows our students to learn to code on that program in one semester over 14 weeks. And so far now, over the space of 4 semesters, our students have created over 20 working legal applications for not-for-profit agencies in South Australia. And that's really about enabling the access to justice. So you'll see on the screens that follow an example of the iRefer app, which is for families in breakdown who are going through the family court process to resolve child custody disputes or property disputes or divorce. And this application is being formally, it was developed by our students and is being formally launched by the Family Law Pathways Network, which is a national Australian body, in a couple of weeks' time. So if someone comes to the family court in Australia and they've got some queries, they work through the app by telling us where they're from, they select the category of service that they're requiring, that provides them with some further links and enables them really to access information that would be extremely difficult for them to access otherwise. There's a huge amount of work and understanding the legislation that's gone in behind that, but it's been possible for our students to create that. Another application that's been created for our students is around responding to the rights of persons with disabilities. So what happens when they encounter discrimination? One of the key things that will help them is if they understand the legal process early and also make a record of what's happened to them. And so this application was designed by our students for a law firm here in South Australia called Equality Lawyers, which represents persons with disability, living with disability, and enables them to report instances of discrimination. And I'll just take you through some of the steps that someone using this app might work through. I can provide later on some links so that you can have a look at these apps yourself. And so that app takes all that information, it's available on someone's phone, it automatically generates a report that goes to the law firm that allows the law firm then to respond to that person, provide them with advice in a timely and targeted way, really revolutionising the way information about the law and advice about the law is being provided. So these are just some of the government and not-for-profit organisations that our students have been working with to create working apps. And we're very, very proud of the role that our students are having in impacting and increasing access to justice in our state. But we've discovered in the last 2 years that we've had a number of inquiries from lawyers